A living will is a legal document that allows you to state whether you want life-sustaining treatments, such as ventilators or feeding tubes, if you become unable to communicate due to a terminal and irreversible condition. This ensures that your medical preferences are known and followed. In this video, we'll cover the essentials of living wills in Louisiana, including who can create one, when it takes effect, and common questions about making and updating your living will. Let's get started. Why would I need a living will? Control over medical treatment. A living will ensure that doctors and family members respect your wishes about life-sustaining treatments if you're unable to make decisions. Avoiding prolonged suffering. You can state that you do not want treatments that will only extend the dying process if recovery is not possible. Reducing stress for family. Without clear instructions, your loved ones may struggle to make difficult medical decisions on your behalf. A living will remove that burden. Preventing disputes. Without documented wishes, family members may disagree on what should be done, leading to stressful conflicts or even legal battles. Ensuring medical providers comply. A living will is legally binding. It only takes effect after 2 doctors certify in writing that you have a terminal and irreversible condition, ensuring your wishes come first. Who can create a living will in Louisiana? Any adult 18 or older can create a living will. To be legally valid, it must be signed in front of 2 competent adult witnesses who are not related to you by blood or marriage and do not have any claim to your estate. Can a living will be made verbally? Yes, but only under specific conditions. A person can make a verbal living will, but only if they have been diagnosed with a terminal and irreversible condition, and they state their wishes in front of 2 competent witnesses who are not related to them and have no financial interest in their estate. However, a written living will is strongly recommended to avoid confusion or legal disputes. Who can make a living will on behalf of someone else? If an adult has not created a living will and is unable to make medical decisions, Louisiana law allows these individuals to decide on their behalf, in this order: 1. Court-appointed guardian. 2. Spouse, if not legally separated. 3. Adult children, as a group if they agree. 4. Parents, as a group. And 5. Other close relatives by descent, as a group. If no family is available, a court may appoint a guardian or curator to make medical decisions. Are witnesses required for a living will? Yes, your living will must be signed by 2 competent adult witnesses who are at least 18 years old, are not related to you by blood or marriage, and do not stand to inherit from your estate. When does a living will take effect? A living will only takes effect after 1. 2 doctors examine you. 2. 1 doctor is an attending physician. And 3. They certify in writing that you have a terminal and irreversible condition. Only then will your living will be followed. To create a legally valid living will, you should include Statement of intent. Clearly state that you do not want life-prolonging treatments under certain conditions. You may also request only comfort care to manage pain. Conditions for effectiveness. Confirm that your living will apply only if 2 doctors, 1 being your attending physician, certify that you have a terminal and irreversible condition. Oregon life-sustaining procedures would only prolong the dying process. Preferences for life-sustaining treatment. Specify whether you want or do not want the following: artificial nutrition and hydration, feeding tubes and IV fluids, respirators, ventilators, cardiopulmonary resuscitation, CPR, kidney dialysis, and other life-prolonging medical interventions. Comfort care instructions. Confirm that you wish to receive pain management and palliative care even if other treatments are stopped. Special instructions or limitations. Include any personal beliefs or specific medical instructions. Signatures and witnesses. Sign and date the document in front of 2 impartial witnesses according to Louisiana law. Notarization is not required but is recommended for added legal protection. Can I make changes to my living will? Yes, if you want to modify your living will without revoking it completely. 1. Create a new version with your updated preferences. 2. Follow the same legal requirements, including signing, dating, and witnessing. And 3. Clearly state in the new document that it replaces any prior living wills. Can I revoke, cancel my living will? Yes, you can revoke your living will at any time. Reasons for revoking or updating it may include changes in your medical preferences, major life events like marriage, divorce, or serious illness, and new advances in medical treatments. To revoke your living will, destroy the document or sign a written statement canceling it. What happens if I don't have a living will? Without a living will in Louisiana, your medical care decisions will be handled as follows. Your closest family members or legal representative will make decisions for you. If no family is available, the court may appoint a guardian or curator, and life-sustaining treatment may be provided by default, unless a legal representative decides otherwise. Does Louisiana honor out-of-state living wills? Yes, Louisiana may honor out-of-state living wills. However, there may be legal differences between state laws. Check out our website to learn more about how out-of-state living wills apply in Louisiana. For more details on living wills and legal information, visit louisianalawelp.org, where you can also find sample forms and additional resources. Thanks for watching.